Enforcing Canada's new methane regulations. In April, the federal government tabled a new set of regulations directed toward reducing significantly the level of emissions from the upstream oil and gas industry. And for those of you that are not familiar with the term upstream, that refers to exploration and production activities and operations within the oil and gas industry. These regulations are directed toward a significant source of Canada's methane emissions. Environment and Climate Change Canada has been monitoring the level of these emissions for a number of years and have reported, took this off of a website in 2017, something like 44% of the emissions are from the oil and gas industry. For the council that are listening, these regulations will be phased in over the next 5 years. Given the fact that they were only tabled in April of this year, we do not have a completed enforcement action yet. But, and if I was discussing these things with my clients, I would note that a similar set of regulations have been adopted in the United States. The U.S. Environmental Protection Agency in 2012 released their first set of these regulations. This was the first time in the United States where they decided they needed to limit emissions from hydraulic fracturing of oil and gas wells. Then, in 2016, so 2 years before our government has tabled its federal regulations, the U.S. released a second set of regulations directed towards facilities, processing facilities, which are the focus of our Canadian regulations. And this because the focus of this conference is enforcement, in the U.S. in April was the first settlement of an enforcement action under their similar methane regulations, and the company, which is a natural gas processing company, it's cost them $2.6 million. That's what they've settled for. And so I'll be taking a look at this case, the Mark West case, and discussing what the types of issues are that have arisen in that prosecution. I've identified 14 key points, which I'll be discussing towards the end of my presentation, where I can see the types of issues that have already arisen in the United States and have been dealt with could easily arise here in Canada. And whether you're defending the corporation that's been charged or whether you're on the regulatory side representing the regulator, bottom line is these were subject to negotiation, and ultimately both parties in the U.S., company involved, and the regulator decided it was in the best interest to settle rather than to proceed with the costly litigation process. So in terms of these regulations, the regulations, and again, these were adopted pursuant to Section 3321 of the Canadian Environmental Protection Act. They're referred to as the regulations respecting the reduction in the release of methane and certain volatile organic compounds, in quotations, upstream oil and gas sector. And again, they were published in Part 2 of the Canada Gazette in April. The title, to me, which really conveys what these regulations are designed to do, plugging the holes. Both literally and figuratively plugging the holes. These regulations plug the holes in the existing provincial schemes, which were developed decades ago, and they literally plug the holes. There's three major sources of our emissions, our methane emissions from the upstream oil and gas industry. One of them, equipment leaks. The second one, a process called venting. Certain types of oil and gas industry equipment have vents. And unlike equipment leaks, which are unintentional, this venting is a process where natural gas, and keep in mind methane is a major component of natural gas, is directly released into the atmosphere in a process called venting. It runs through vents. And again, that is another significant source. And then the third one, which is a potential increasing source, is in the context of hydraulic fracturing of oil and gas wells. And the reason I say that it's a potential increasing source, if not properly managed, which is what the regulations compel, is proper management, in light of what we've heard recently in British Columbia with the new LNG project that has been announced and endorsed by both the Prime Minister and the Premier of British Columbia. The more shale oil and gas wells that you drill, the increased potential for emissions if these things aren't properly managed. So that leads me to the second point, and that is provincial emissions reduction schemes. I was thinking about these new regulations, and if we look at methane and the history of methane, our first production of methane was an accident. And it goes back to 1883 when they were building something called the Canadian Pacific Railway. And in 1883, they were running this railway across the prairies where we did not have provinces at that time. They were all federal lands. They were part of something called the Northwest Territories. And the train was running through an area of southeastern Alberta, very close to the Saskatchewan boundary, and semi-arid area. The workers, railway workers, were looking for water. And in the process of drilling their water wells, they got a surprise. Methane, natural gas. 1883, what do you do with this gas that you've just exposed? Well, they thought about this, and they thought, well, we might be able to use it for lighting. And, gee, it gets pretty cold out in the prairies. We might use this natural gas for heating buildings and subsequently greenhouses. And the reason that's relevant to these 2018 regulations is at the heart of these new federal regulations is optimizing the use of a valuable energy resource rather than allowing this valuable energy resource just to be released into the air. As a result of most of the oil and gas development being on provincial lands, specifically starting with Alberta, then Saskatchewan and British Columbia, the existing regulatory schemes, the first one dating back to 1932, did they consider climate change? No. They were strictly focused toward minimizing the release of wasted methane. Their focus, and again going back to the 1930s, and there's a carryover today, is minimizing the waste of that resource for economic benefit. And the regulations in place, and by the way, after Alberta introduced its first one, and they're called Oil and Gas Conservation Regulations, Saskatchewan looked at what Alberta had done, copied what Alberta has done. They have an Oil and Gas Conservation Act, just like Alberta. So Saskatchewan adopted this in the 50s, and then BC, when their oil industry took off, same sort of thing, they followed Alberta. And when you look at the weaknesses of all of these schemes, standards to reduce emissions, because Alberta is the largest producer and has the largest vested interest in this, it's done the most work. The British Columbia government, if you look at what they've done to date, is they basically said, well, we want to make sure whatever action we take is kind of the equivalent of BC, or the equivalent of Alberta and Saskatchewan, other provinces, so they're kind of monitoring what Alberta's doing. And as we discussed yesterday, Saskatchewan, they have a different perspective on these things thus far. But if what's happened already in the U.S., these other states, some of the state oil and gas conservation schemes, and the key federal system in the U.S., get the same sort of response here. It's really more stringent requirements to further reduce emissions for the purpose of responding to climate change. So, turning to the third bullet point, reducing emissions under the federal regulations. The focus of these regulations is on the largest sources. And again, from an enforcement standpoint, this makes sense. Because there's been more, for example, than 200,000 oil and gas wells that have been drilled in the province of Alberta alone. And from an efficiency standpoint, is it possible, and some of these, by the way, old oil and gas wells that were drilled when the federal government was regulating the development, they don't even know where some of these oil and gas wells are located because they didn't have licensing regimes in those days. But can you imagine having to send out a person to every site to check to see what the extent of these emissions are from these different sites? That may come. But as a starting point, these new regulations focus on the largest sources. And the largest sources are the larger natural gas processing facilities. Specifically, when you look at the first source here, equipment leaks account for 34%, 1/3 of the emissions. And common sense will suggest that you can virtually eliminate these equipment leaks by requiring leak detection programs and requiring a timely repair of leaks that are detected. And that is exactly what you find as requirements in the new regulations. And what you also find is when you look at the existing provincial regulations in Alberta and BC and Saskatchewan, where these are the largest problems, these are recommended practices in the existing provincial systems. And so really the new regulations are clamping down and saying we have to be more serious about these things. And at the same time, and this just happened at the end of September in Alberta, notwithstanding the comments of our Premier, given what's happened with the Trans Mountain Pipeline, well, temporarily we're going to pull out of the Pan-Canadian plan, so that's the political. The actual action of the Alberta Energy Regulator, and I think what they're doing is test piloting this program, is they've basically adopted requirements. Keyword being requirements rather than recommendations, along the lines of what you see in the new federal regulations. And I would suspect that they're kind of test piloting these to see how they work out, and then they may well extend these to the rest of the province, because there's another, we use what are called directives, which is under review for consultation on a broader basis. What Alberta is doing is looking at, and they've commissioned 3 studies, the Alberta Energy Regulator, looking at the best technology to reduce emissions. Because again, these things cost industry. The Alberta government has calculated that the new regulations will cost $780 million. So what technology, because there's a range of costs based on the different types of technology that can reduce the emissions to the standard that is outlined in the new regulations. So that's equipment leaks. Venting from facilities, well, this is deliberate. Now, in the new regulations, and again, this corresponds to what's done in other countries and in the provincial regimes. At a first glance, you might say, well, the easiest way of dealing this is just prohibiting venting. But it's more complicated than that, because this is an explosive gas. And the idea is that in certain more emergency types of circumstances, if you don't release this gas, then there's the potential for explosions, there's health and safety risks. And interestingly enough, the American equivalents, after adopting their standards in 2016, they've now amended the initial requirements to account for emergencies, just like what I outlined. And my suspicion is, again, federal government's looking at what the EPA is doing, and so there's more flexibility for that reason, which I think is a sound reason. But having said that, it's clear, because venting is a significant source, and indicated about 23% of the emissions, that there needs to be a reduction in venting, and the alternatives that are provided to these operators to me are sound. You must capture the methane that you're currently venting and use that methane for a useful purpose, which would be like heating facilities, generating electricity in your facility. If you can't do that, pipe the methane and put it into a pipeline and sell it. Those are what we call beneficial uses. And by the way, those are the recommended practices in the existing provincial systems. Now, the idea is most of the methane will be treated that way. And in the new regulations, there's a standard. 95% of that methane has to be captured and treated that way, not vented and wasted. Having said that, there's an appreciation that a small percent can be flared. Flaring does produce some carbon dioxide, contributing to GHG emissions, and smaller percentages of other things. But the difference between this flaring versus venting is if you have an efficient flaring process, that flaring results in 2% of the methane as opposed to venting methane. So again, that is provided for under the new regs. The third potential source is something that we've all heard about, hydraulic fracturing of oil and gas wells. And again, the much greater experience in the US, because they've been the ones that pioneered development. There's gas in the fluids that flow back to the surface of the ground, the methane, natural gases in those fluids, and if not properly managed, that can add to our methane emissions. In the case of the oil and gas well sites, the new regulations prohibit venting. And again, the existing provincial regulations recommend that you reduce the amount of venting. The new regs say you're not allowed to vent, which will reduce emissions. And the idea is you have to capture that, just the natural gas, just like other facilities. So those are the three significant things. The other thing is obviously these regulations cost a significant amount of money. The federal government has estimated it'll cost $3 billion, 2.9 change. But because the focus is capturing wasted gas, the actual cost, or they factored in the value of that wasted gas, is $1 billion. So we're talking about ultimately $2 billion. Companies have to plan for and budget for the equipment upgrades or the equipment replacement to reduce significantly our methane emissions. So that takes us then to this Mark West enforcement case. And the key thing with the Mark West enforcement case, what happened, and I think this was kind of a wake-up for industry, and there's charges under both the Clean Air Act and a state act. This occurred in Pennsylvania. So this would be kind of the equivalent, thanks, of provincial, a joint provincial and federal action. And by the way, when it comes to hydraulic fracturing of oil and gas wells, the new regulations recognize that the existing Alberta and British Columbia regulations are satisfactory. So as long as the oil and gas companies satisfy those 2016 provincial regulations, only in Alberta and BC, they don't have to comply with a second duplicate set of regulations. But in terms of enforcement, what happens? This company had workers arrived at a pipeline site to carry out routine maintenance. These maintenance activities were performed daily, weekly, or monthly to avoid the buildup of something called condensate and gas gathering and transmission lines. These operations required venting. Federal government's agents arrived at the site for an inspection, approximately 8 a.m. They halted the routine maintenance activities, began questioning the workers, and collected samples. The agents finished their site inspection, made requests for production and documents. No additional action was taken by the federal agents at that time. What does the managing counsel for the company say? He notes that the execution of the federal search warrant, when he looked at the terms, it became clear that the search warrant was based in large part on a number of misconceptions. Specifically, the operations were not occurring in secret, as they were routinely scheduled. They did not vent the volume of emissions that were anticipated, a much smaller amount. He notes the public was not categorically at risk, and the workers were not categorically at risk. That's his take. The action taken by the EPA, state regulators, was framed as an air pollution emergency claim under the Clean Air Act, comparable in terms of our SEPA provisions. Counsel for the defendant reported that the basis for the search warrant and preliminary discussions with the Department of Justice focused on protecting industry workers and public health, which is one of the objectives as well of our new regulations. He notes that previous and subsequent scientific studies demonstrate there was no imminent and substantial danger to workers or the public. And he notes the EPA, state regulators, and the industry have traditionally been under the impression that emissions from the operations in question were de minimis, minimal. However, after the site inspection and reviewing its operations, the defendant company conservatively identified a small subset, less than 10% of its sites, where the emissions might have been above Pennsylvania emissions minimal permitting thresholds. So, the outset of this is negotiations ensue, and as they say, the agreed settlement, $610,000 US, and the completion of 3 supplemental community environmental improvement projects designed to reduce emissions from oil and gas facilities, and that's at a minimum cost of $2 million to the operator. So you're looking at $2.6 million there. And as I note in my paper, could this happen here, given the U.S. regulations have the same objective, reducing emissions to protect the public? In our regulations, it's Section 1. It can easily arise here. In the paper, I've listed 14 different issues and how they've been resolved. And in conclusion then, so you can take a look at those, because I would anticipate the negotiations in Canada would run similarly. The new regulations will further reduce the volume of methane that currently enters the atmosphere from equipment leaks and venting at facilities, and further prevent emissions from new oil and gas wells. Starting January 1st, 2020, facility operators must start implementing equipment leak detection and repair programs. The regulations require timely implementation of these leak detection and repair programs, and 3 annual inspections of facilities are mandated to make sure that the leaks have been repaired and that the venting levels are satisfied with. And as I mentioned before, these regs are being phased in, some provisions 2020, some 2023, to allow industry to budget for these. The regulations create a cap on the volume of emissions that can be vented. There's both a monthly cap and an annual cap, cumulative annual cap. And clearly, Environment and Climate Change Canada has the technical capability to monitor these emissions levels, and they specify the types of technologies to be used to evaluate whether the emissions levels have been exceeded. As I noticed, there's 2 basic options. The preferred option now is to capture and use otherwise wasted methane, which again, these are recommended practices in the existing provincial systems, things like facility heating or generating electricity. The second, less desirable option is efficient combustion or flaring of natural gas. Not as desirable because it still produces emissions, but a much smaller volume. At oil and gas wells versus these larger facilities that produce a much larger volume of emissions, venting is prohibited. And as there's no reported Canadian prosecution under the new regs, it's not surprising, the Mark West case that I discuss in my paper, I think provides guidance as to the types of issues that have arisen in and the first enforcement action in the U.S. under a similar framework. And again, that was resolved. It was settled in 2008. Thank you.